exactly is Royal Assent? When Parliament passes a new law, many people may assume that it immediately becomes a law nationally, automatically. But within the British constitutional system, there is still one final stage before a bill formally becomes an Act of Parliament, and that stage is called Royal Assent, and it is issued by the monarch. Now this raises an important question in and of itself. Can the monarch actually refuse to approve a law passed by Parliament? Some may believe that the monarch still holds a hidden power of veto. Others may believe that the monarchy has no constitutional role to play at all. But the reality sits somewhere between history, law, convention, and politics. So in this episode of Politics 5, we will explain what Royal Assent actually is, and whether the monarch can realistically refuse it in modern Britain. Royal Assent is the final formal step required for a bill to become a law in the United Kingdom. Before a proposed law becomes an Act of Parliament, it must pass through the House of Lords, the House of Commons, and then receive Royal Assent from the monarch. Once Royal Assent is granted, the bill officially becomes law. Now, historically, monarchs once held far greater political power than they do today. Centuries ago, kings and queens were directly involved in governing and could refuse legislation passed by Parliament. But Britain's constitutional system has gradually evolved. Over time, Parliament became politically dominant, while the monarchy became increasingly constitutional and ceremonial in its role. Now, this is important to understand. Legally, Royal Assent still exists as a formal constitutional power of the Crown. But by constitutional convention, the monarch is expected to act on the advice of ministers and does not normally refuse legislation passed by Parliament. So in practice, Royal Assent today is considered automatic. In fact, the last monarch to refuse Royal Assent was Queen Anne in 1708, and she refused a bill concerning the Scottish militia. Since then, no British monarch has blocked an Act of Parliament, and that long period matters, because over time, constitutional conventions can become extremely powerful within the British system. And one of the strongest conventions today is that the monarch does not publicly obstruct the democratic decisions of Parliament. Now, this helps explain an important constitutional principle. Britain is a constitutional monarchy, but Parliament makes the law. The monarch reigns within a constitutional framework shaped by democratic government and parliamentary sovereignty. Now, technically, legal scholars sometimes point out that because Royal Assent still formally exists, a monarch could theoretically attempt to refuse a bill. But doing so would likely trigger a major constitutional crisis. Why is that? Well, because the modern monarchy depends heavily upon political neutrality. If a monarch openly blocked legislation passed by elected MPs, it would place the Crown directly into a political conflict with Parliament. So yes, in essence, the monarch could block a bill, but the success or failure of such a move would depend on the strategic makeup of Parliament at the time, and it would be a huge gamble for the monarchy itself. The more likely outcome would be a political and constitutional confrontation, with Parliament seeking to legislate to move the monarch's Royal Assent veto altogether, and further reducing the Crown's role to one that is largely symbolic and purely ceremonial. So if the monarch were to refuse a bill, the monarch would be heavily dependent upon public support to justify such a dramatic intervention, and that would be the gamble. A refusal of Royal Assent might preserve the veto in the short term, but it could also provoke the very reforms that permanently remove it. So, although the legal mechanism still exists in theory, constitutional convention makes its use extraordinarily unlikely in practice. And this distinction between legal theory and political reality appears often within the British Constitution. At any given time, there are many online commentators that may wax lyrical about the King's ability to either veto a bill or to dissolve Parliament at will. But the actual reality is far removed from a desktop mic and a keyboard. Because Britain's system depends not only upon written law, but also upon restraint, precedent, convention, and political expectation. So in conclusion, Royal Assent is the final constitutional step that turns a bill into an Act of Parliament and therefore into a law. Although the monarch formally grants approval, modern constitutional convention means Royal Assent is almost always automatic. This has been Politics 5. British politics explained in 5 minutes.